Roni Reaves update on the open records request. Let's get into it. All right, this is the email I sent to Ms. Humphreys, the custodial record at the Baldwin County Sheriff's Department, asking for clarity of the public record, right? Please confirm whether there exists any court order, judicial ruling, or prosecutorial directive restricting the release of the 911 recordings in the matter of Veronica Roni Reaves, case number 1725606. If such an order or directive exists, please identify it and provide the issuing authority. If none exists, please confirm that in writing. Thank you for your attention. Respectfully, Lamar King. All right, this is a response. Mr. King, the response addressed your request received January 28 for the identity and issuing authority of any court order, judicial ruling, or prosecutorial directive restricting the release of a 911 recording in the matter of Veronica Reaves, case number 1725606. No records were located indicating the existence of any such court order, judicial ruling, or prosecutorial directive, right? The requested 911 recording is being withheld pursuant to OCJ 50-18-72A4, as it constitutes a record compiled or maintained in connection with an open and ongoing lawful enforcement investigation and therefore exempt from public disclosure at this time. But see, here's the thing. All public records shall be open for personal inspection and copying, except those which by order of a court of this state or by law are specifically exempt from disclosure. What this statute establishes is the sheriff's office is the custodian. The custodian job is administrative. It receives requests, it applies statutes, it produces or withholds records. The custodian does not decide admissibility of evidence. The custodian does not decide what's prejudicial for trial. The custodian does not decide what the public shouldn't hear, right? Those are judicial functions, not record functions. Now, can a sheriff legally withhold a 911 without a court order? Legally, yes, but only under a specific statute, right? Not for emotional, reputational, or speculative reasons, right? This is where the confusion usually happens. The statute they're using is OCGA subsection 50-18-72A4. Records of law enforcement agencies in any pending investigation or prosecution of criminal or unlawful activity shall not be subject to inspection or copying, right? Keynote, this statute gives the agency discretionary authority to withhold records temporarily during a genuinely pending investigation, right? This authority does not come from a court order. It comes directly from the statute, okay? So when they say we're withholding under subsection 50-18-72-A4, that part is legally allowed. But this is the part where they overstep. They did not overstep by withholding under the statute. They overstep when they reference trial strategy. They overstep when they reference dying declaration admissibility. They overstep when they reference internet sensationalism. Why? Because none of those parts are of subsection 50-18-72A4, right? Let's look at the rest of the statute, right? It says, provided, however, that an investigation or prosecution shall no longer be deemed to be pending when in all direct litigation involving such investigation and prosecution has become final or otherwise terminated. This is law. That says pending is not forever, okay? What the statute does not say, it does not say that investigations are pending forever by default. It does not say that age is irrelevant. It does not say that agencies can rely on potential future prosecution indefinitely. And it also does not say that public reaction is a factor, okay? That is legal failure. Huh? The legal vulnerability is they justify the withholding using concepts like trial admissibility, dying declaration, public reaction, that are not part of the open record statute. And that's the distinction that new media wants to make publicly, okay? Now, a court order is required when an agency claims a restriction outside of the statute, right? A court order is required when an agency claims disclosure would violate due process, prejudice a jury, affect admissibility, interfere with specific prosecution. Those are judicial determinations, right? That's why we followed up with, is there a court order? And their answer was no, which means they are relying only on subsection 50-18-72A4. Not on judicial authority, not on prosecutorial directives, okay? So under Georgia law, the sheriff's office is allowed to withhold records during pending investigation, but only under the open records statute. What they cannot do is turn an open records decision into a trial strategy decision or a public relations decision. Those determinations belongs to a judge, and the sheriff's office has confirmed that there is no court order in this case. All right? Now, I want to be clear about something. I've spoken with law enforcement officials who believe in open communication. I've seen what an open door policy can do when it comes to resolving misunderstandings and correcting situations. Transparency doesn't weaken the system, it strengthens it. This isn't about politics, people. It's not about personalities. It's not about pressure. It's about family. It's about lives. It's about children asking to hear their loved ones' last words. And the law saying that request deserves a clear, lawful answer. We still on it. Y'all stay with me. Like, follow, subscribe, share this thing out, because the truth will never be silenced. Be great today. Peace.